Daniel Magoo.
All right. What are we doing on this today?
Um, Your Honor, I have in regards to case number 25F4-523, I have a couple things I'd like to point out about a couple of the matters here today.
Go ahead.
In regards to count 3, MCL 750197, lawfully detained or imprisoned in jail or confinement. Judging by the definition of the statute itself, Your Honor, it compels us to conclude that one has to be lawfully imprisoned or in jail. Jail being a facility operated by a local unit of government for detention of persons charged. At this location, defendant was located in a hospital and not a confinement by government agency or jail. So I'm requesting that that charge is invalid on its face.
To be addressed. That would be addressed at a preliminary examination, sir, as to the sufficiency of the charge. So if you're making a motion that I dismiss it at this point, that motion's denied.
Okay. Further in count 2 and count 1, actually, Your Honor, both of these were, I don't know the procedural process or when it should get raised, but both of them are Fourth Amendment violations. And furthermore, on count 2, MCL 257.904, that the license of the defendant was revoked or suspended, given the statute as well, Your Honor. That would require the prosecutor to prove that the license was revoked or suspended at the time of the arrest, and that defendant was notified, and that the defendant operated a vehicle on a highway or roadway. I challenge the prosecutor to prove all 3.
Sir, do
Yes,
you
sir.
wish to have a preliminary examination in this?
I'm making sure we're prepared for it, but yes.
What'd you say?
Making sure we're prepared for it, but yes, I am. What are the other options? I'm requesting that all the charges are dismissed. The motion.
Buckle up, folks, because today's courtroom showdown is about as wild as they come. Our star of the circus? None other than Daniel Magoo, a sovereign citizen who believes he can outsmart the system with legal word salad and a whole lot of misplaced confidence. If you've seen Eric Martin, you know the bar for a dumbest sovereign citizen is already low, but Magoo might just dig a new basement level. Now here's what makes this case juicy. Magoo isn't just facing a parking ticket. No, we're talking multiple charges across multiple dates. From fleeing police, to driving under the influence, to allegedly escaping lawful custody. And what's his defense strategy? Spoiler: argue that being in a hospital doesn't count as custody. Yeah, you can't make this up.
Then it might be that they would be dismissed at that point, but they're not going to be dismissed on an oral motion before this.
Ms. Lundy has let me know that all paper discovery has been sent to Mr. Magoo in jail. There are USB drives with video. A number of agencies were involved in the Michigan State Police case, so they responded to assist. I believe she has obtained all of those videos, and those will be sent interdepartmental to jail staff to serve on Mr. Magoo, and I expect those to be in the interdepartmental mail tomorrow.
Got it. Okay, so we're not ready. He hasn't gotten the video.
He has all paper discovery, but he does not have all video discovery. I expect that'll happen. So I'm not sure.
So, Mr. Magoo, are you going to have an objection to an adjournment so that you can see all of the discovery that they have prior to setting this for preliminary examination?
Your Honor, I didn't know what hearing I was prepared for today. I was preparing to cross-examine the officers today, with or without the the video evidence. So given that that's not the case and the officers are not here, I would like a speedy trial. I would like to invoke my right to a
All right.
speedy
So
trial.
you want your preliminary examination. Those are coming down to the jail to him.
I expected you would have him early next week, so.
And there it is. The Sovereign Citizen Classic. I demand all charges be dismissed. McCoo argues that being in a hospital isn't the same as being in custody, as if the sheriff just dropped him off for a checkup and forgot. Here's the thing. Custody isn't about the location. It's about control. If law enforcement delivers you to a hospital under their authority, you're still in custody. Judges know this. Prosecutors know this. But sovereign citizens cling to loopholes that don't exist. Question for you guys. Do you think McCoo actually believes this? Or is he just throwing spaghetti at the wall hoping something sticks?
If the court follows its normal setting for preliminary examination, I would expect.
I would set it for the 19th and then
Have them as well.
he'd have them well in advance, and I guess I'll do it that way. Prior to setting the preliminary examination as being a critical process, a couple of things that the court wants to do. Mr. McGoo, starting in case ending in 0979. Mr. McGoo, you are before the court on a felony complaint that alleges 5 different counts, excuse me, fleeing and eluding 4th degree, which is a felony punishable by up to 2 incarceration, $2,000 fine plus court costs. Count 2 is operating an unregistered vehicle, which is a misdemeanor, punishable by up to 90 days. Operating without security, which is a misdemeanor, punishable with not more than 1 year or less than a $200 nor more than $500 fine plus court costs. Count 4, operating while license suspended, denied, and or revoked. That is a misdemeanor, punishable by up to 93 days.
Notice how McCoo keeps challenging the prosecutor to prove everything. That's not strategy. That's literally how trials work. Of course, the prosecutor has to prove their case. That's why there are hearings, discovery, and witnesses. Sovereign citizens love to pretend that demanding evidence somehow dismisses charges early, but the judge shuts it down quick. We're not dismissing on your oral motion today. Translation? Nice try, but no free pass.
$500 fine plus court costs in your vehicle would be subject to mobilization. Count 5 is refusal to obey a lawful traffic order of a police officer. That's a misdemeanor, punishable by up to 90 days, $100 fine plus court costs. Those events are alleged to have occurred on July 3rd, 2025, I-94 near Parker Road in Scioto Township. That is on the one case. On the other case, which is a 3-count complaint, that 3-count complaint alleges that on March 27, 2024, location of Dexter near Arcona in the city of Milan, Washtenaw County, state of Michigan, that you did operate a motor vehicle while intoxicated. That's a misdemeanor, punishable by up to 93 days, $500 fine plus court costs. There is, however, a third offense notice which transforms this into a felony charge. It's punishable by up to $500 to $5,000 fine plus court costs, 1 to 5 years in jail, probation with 30 days or 1 year in jail, or at least 48 hours to be served consecutively, and 60 to 180 days community service, any rehabilitative programs the court deems necessary. Court could order you to pay the cost of the prosecution, plus the cost of any emergency governmental service.
Here, McCoo suddenly pulls out the speedy trial card, insisting his rights are violated if things aren't moving fast enough. On the surface, that sounds smart, but in reality, discovery takes time. The state has to gather evidence, video, and witness testimony, and you can't rush that without risking mistakes. Judges balance the defendant's right to a speedy trial with the public's right to a fair trial. It's like McCoo thinks shouting speedy trial is a magic spell that forces the court to bend to his will. Spoiler, it's not.
And your vehicle would be subject to mobilization. Count 2 is operating while your driver's license was suspended, denied, and or revoked. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Count 3 is lawful escape from custody or escape from lawful custody, excuse me. That's a misdemeanor punishable by up to 1 year, $1,000 fine plus court costs. Mr. Groove, I would just ask, do you still wish on representing yourself, sir?
Your Honor, I do, I will. I have requested assistance given that I am incarcerated and I have no way to.
Do you wish to be represented by an attorney, sir?
I would like legal assistance.
What do you mean by that? Would you like to be
Well,
represented by?
I've called the
Well, Mr.
prosecutor.
McGrew, we go through this every time. So here's what I'm going to do. I'm going to advise you that there are great perils in representing oneself. I've told you about that before on numerous occasions. That I would treat you the same as I would treat anybody else. You would have to know the Michigan court rules. You'd have to know courtroom procedure, and that you would be treated the same, not any more favorably, not any worse, as you would go through these proceedings. If you wish to represent yourself.
And here comes the biggest plot twist so far. After refusing help and insisting he can represent himself, McCoo finally says the magic words. I would like legal assistance. For sovereign citizens, this is basically admitting defeat. Why? Because their entire gimmick is built on rejecting lawyers and claiming, I know the law better than anyone. The judge even warns him, representing yourself is dangerous, and you'll be held to the same standard as a licensed attorney. And for once, McCoo does the smart thing. He accepts a public defender. What do you guys think? Smart move? Or is he just setting up someone else to clean up his mess?
You may proceed with the court's admonishment. I've advised you as to the penalty, the charges, the maximum penalties. I will now ask you the question, and I'm not going to just keep going around and around in circles when I ask you this question. Do you wish to be represented by counsel? If you wish to be represented by counsel, this court will ensure that counsel is appointed to represent you.
If
That is a yes or no.
Classic sovereign citizen maneuver. When all else fails, scream, due process violation. McCoo cites case law and claims the delay in filing charges proves his constitutional rights were trampled. And while citing precedent sounds impressive, here's the catch. He's doing it wrong. Judges hear these arguments daily, and unless you can show the delay caused actual harm to your defense, it doesn't hold water. McCoo is tossing around names like Lavasco and Hernandez like confetti, but without context, it's just noise.
Take that. And so these two cases now become public defender cases.
Thank you, Judge. Torture Feaster, Assistant Public Defender on behalf of the defendant. I believe Your Honor has already agreed to set it for examination.
I will set, he's asked for examination in the case, and so I will set these for preliminary examination.
Okay.
Well, Your Honor, I would ask, given that one of these cases, in regards to the March 27, 2024 case, there is an undue delay. It's been over, I think, 390 some days since the warrant was requested, and this triggers due process violations under U.S. versus Lavasco, People versus Bassard, People versus Rosengreen, and procedural unfairness, Sixth Amendment violations, and I do request that the prosecutor provide provide information in regards to the three-pronged test under People versus Hernandez. One of them, first test being the explanation for the undue delay for 390 some days. The second part of that test being to prove that the delay was not deliberate. And then the third part of the delay or the prong test is to make sure that there was no undue burden on or prejudice on the defendant. And in that regards, Your Honor, I also am requesting that I do have due process 14th Amendment rights as well as 8th Amendment rights. And a lot of these are facially invalid. A lot of these charges are facially invalid, and I'm just requesting that the court grant a personal reconnaissance on my behalf. And for both of these charges, being that we're looking at really just misdemeanors, $500 misdemeanors.
This is where things heat up. Bond. McCoo begs for release, saying he's presumed innocent, but the judge isn't buying it. Why? Because innocence isn't the only factor. It's about risk. And with charges like fleeing police, escaping custody, and a third DUI, the risk